I'm the Marketing and Scheduling Director at our firm. In the back there is Mr. Fales, and he will be giving our presentation here tonight. Before we get started, I'd like to tell you a little bit about our firm. Gary focuses his practice in the areas of estate planning and asset protection. He began his practice in tax law in Manhattan, and after living through the terrorist attacks of 9/11, moved back to his hometown of Las Vegas. Gary has a unique passion for family planning, and tonight he's going to be sharing with you a little bit some issues that virtually no other estate attorneys talk about. And when he's finished, I think you'll agree with me that these very important provisions ought to be included in your respective plans. With that in mind, without any further delay, let me turn the rest of the program over to Gary.
Okay, well, thank you so much. I'm thrilled to be here tonight and to see so many familiar faces as well. One thing that Genevieve did not say about me is that I'm proud of the fact that I'm an Eagle Scout. Now, does anybody know what the Scout motto is? Be prepared. And I think that's going to be an appropriate adaptation to tonight's presentation on dealing with the issues with you while you're alive and with your family members in planning ahead. So with that, I actually want to go through some of the materials that you've been handed out so that to make sure we have everything here. This right here is the outline. If you're married, you're likely to be sharing. Okay, so that's in front of you. You should have a gold sheet of paper, a white sheet of paper with a staple in it, and a long legal-sized piece of paper. Okay? Also, there's an envelope. Does anybody not have these materials? Okay, if not, you can see the receptionist out in the front, and they'll be able to get those for you. So, why are we here? What do we want to learn about? I will address and entertain any of those questions now, and then if I know that we're going to get to it, we'll put it off. But what is it that you want to learn about? I want to make sure that, you know, this audience isn't so large that we can't deal with some of those issues. Yes, sir?
I have a trust that was made in California.
Okay.
I want to know what I need to do, if anything, to make it legal.
Okay, I'm going to actually cover that because we have a lot of people who are coming from out of state. Yes, sir?
We just have a will, and I'd like to know about the living trust.
Okay, good. We will definitely cover that. Anyone else?
Asset protection.
The asset protection elements? We're going to get to that too. All right. Yes, ma'am?
I'd like to know, once I have a trust, how do I update it?
Okay.
Change it, or how do I interact with it?
Excellent question, and we will get to that. Yes, sir, in the back.
You stated that I have a 6 times better chance of being disabled than I do dying. Once I die, what's done is done. But what happens if I become disabled? Who's going to take care of me because I'm a single person? What's going to happen to my estate? Is the state of Nevada going to rape me? Is George Bush going to rape me?
Now, what you need to know is I did not plant that question. Okay, but we're going to nail that one for sure.
Thank you.
Okay. All right. Anything else? Okay. Good. Well, let's get right into it. Get your outlines out. And as you can tell, of course, I have it repeated up here on the screen. So we're going to get going. Now, every estate consists of 2 parts. There's the death plan and there's the life plan. The death plan, everybody's concerned about, well, what happens to me when I die? I want to avoid probate. I don't want to go to court. And that is very important. The question is, did we also take care of the life plan? Okay? And how is that going to affect us? So let's get into the details of the death plan first. Everybody wants to avoid probate. Why? What's so horrible about probate? Because the attorney's expensive. Okay, all correct. Pardon? The time? Okay, that's 2 big ones. I got expensive and time. Privacy. Okay, that's the 3rd one. And you can see that right here, the attorney's fees, the executor fees, the filing fees, those are the fees. Normally it takes at least 9 months to get through this probate process. And then on this last one, the publicity of it, I'll get to that too. All right. The death plan, when it comes to the fees, it's very common. Now, in Nevada, we do not have statutory fees. Okay? We just have what's customary. Many states just simply have what's customary to charge in going through probate. Now, I recently did a probate myself, and there was a piece of real estate in there, and we sold it for about $270,000. Okay, that's a modest home here in the Valley. Okay, I think you would agree with me. And my probate fees were over $13,000. There were other assets. Okay, now why were they so high? It's because we calculate the probate fees based on the gross market value. So if I have a home that's worth $500,000 and there's a mortgage out there for $500,000, what's the gross value? $500,000. The net value is zero, right? There is no net. There's nothing there for me. There's no equity, as we would say. Okay, but the gross value, as you can see, now these probate fees are just the attorney side, and normally it's customary to charge about 5% of the fair market value. So a $200,000 estate is about a $10,000 probate fee. $1 million estate is going to be about a $50,000 probate fee. And people say, I don't want my estate being drained, because oftentimes that's going to be equity. I don't want to see that equity going out to the attorneys. The executor fees are in addition to the probate fees I've listed here. And those are normally a reasonable fee, usually about 2%. So you can get as high as 7% through this probate process. Then, of course, there are these filing fees as well. Okay? So we obviously want to try to drive down the size of the estate as low as possible. The thing preventing that are the appraisals, generally. Now, if we see an estate come in and there's no real estate, we're going to be very hesitant to take this on. Why? Because the attorneys need to know how to get paid, right? It's very easy to get paid if there's real estate, because the funds at closing are going to be divided to make sure that the attorneys get paid. All right, so it's not a place that we want to end up. Does anybody here know who Jackie K. Onassis is? Okay. Jackie K. Onassis, when she died, she had a will. Here it is. Okay, if you want to see who got the Greek alabaster head of a woman, you can see who got it. It's right here. If you want to see who got the other items, you can see it. It's all right here. Why is that? It's because normally in most states, when you die, even if you're not going through probate, okay, the will must be submitted to the court. There must be a filing made to the court. So whatever you did have in your will is going to become a public record. So if we have a will, which in any kind of a death plan or a life plan, we're normally going to have a backup will. We want it to be as sparse and tell us as little as possible about who's getting what. All right? Now, something totally separate from the probate fees. I really want to emphasize this. It's totally different. It's the taxes, the estate taxes. Now, this year, of course, if you die, this just recently changed, you can have $2 million in your estate and not be subject to the estate tax. Now, let me give you one little warning about this. Does anybody here have life insurance? Okay, I do. All right. In fact, another thing you don't know about me, you're going to learn a little bit about me tonight, okay? I have 4 kids, and they're all under 9. I'm a big-time family guy. I love my kids. And I'm just not willing to take the risk that if something happens, there's not actual liquidity. There's not cash. So I have a $2 million policy. I got a lot. Okay? If I die, that $2 million, do you think it will be included in my estate tax calculation or not? Yes. Whoa. This is a surprising group. Most of the time the answer I get is no, it won't be. But you're right. The loud voices I heard were yes, it will be included, and you're correct. Okay, it will be included. So you know something about me already. I'm up to $2 million. When it comes to, I'm already filled up right here. Now, if you can hold out a little bit longer and die in the year 2009, that number goes up to $3.5 million. And then, of course, if you can die in the year 2010, there is no estate tax. So pop quiz, what's the best year to die? Okay, you got it. A little warning here, though, of course, is that right now as the law stands, in the year 2011, that number is actually going to go down to $1 million. Okay? Now, people love to ask me my opinion about the estate tax and what the Senate's going to do. And where this number actually is going to end up, because there's been some talk about repealing or not. My strong belief is that no matter what happens, I do not think that they're going to repeal permanently the estate tax. Now, I used to think that, that was a real strong possibility until the Gulf War and until Katrina and until the budget started really having some problems. Now, if we need taxes, who's going to be the best kind of person to tax? Wealthy, I'll put it together. Wealthy dead people, okay? All right? Why is that? They don't vote and they don't complain. Okay? So, that's precisely why I always believe that there's going to be some sort of an estate tax around. Now, let me take you through this a step further. The other thing that you're going to learn a little bit about is my wife. Let's say that my wife and I'll use her in these examples. Let's say that we have an estate and there's $2 million of life insurance, and let's say we have $2 million of other assets, okay? So we're up to $4 million, all right? Now, if I die first, and then she dies of a broken heart a week later, okay, which is likely to happen. If that happens, then what is the size of the estate when we go to calculate the estate tax? $4 million. Okay, I get to subtract 2, because that's my number, which means that the remaining 2 will be subject to the estate tax. I'm going to show you how we get around that, but the way it stands right now, if we do nothing, then my estate, my $2 million, my half, dumps into her half, and she's left with this $4 million, and she only gets one exemption. All right, how do we take care of these problems? First of all, we need to understand, how did we get to probate in the first place? Let's take probate first. The way we got into probate is the decedent, that's the person who died, the decedent died owning assets that require his or her signature in order to sell. In other words, dead people can't sign their name, can they? Who's going to sign the name on the house if it's in your name? Well, I've had somebody say, well, the power of attorney. The power of attorney dies with you. Okay, so that's not going to be any good. So we need somebody to transfer the asset, so we're going to get a court order. The judge is going to assign somebody, they're going to get letters testamentary, and then they're going to walk into the title company, to the investment account or wherever, and they'll be able to sign their name in order to transfer. Now, something else. In the state of California, for example, even if you have assets in your name that require a signature when you die, as long as those assets are under $100,000, you're okay. Idaho, under $75,000. Nevada, under $20,000. Okay? So if you have assets in your name over $20,000, you're going to probate. All right? So here's how we're going to avoid that. We're going to give everything away to something that you have full control of. Now, you could give it to your spouse if you're married, but that's circular, isn't it? What if there's a simultaneous death? Okay? So you can't give it to each other, and you can't give it to the guy on the street and hope that you can trust him. Because, of course, you will fully lose control if you give it away to somebody else. So we'll give it away to this trust right here, and you will be the trustee. You will have full control. The trustee has full control. Now, the trust doesn't die. You can see here that we have successor trustees here, here, and here. They will take over just in case you die or if they die, and so on and so forth. So now the assets are not in your name. They're in the name of the trust. And now you're free to die with under $20,000 in your name if you're in Nevada. Okay? It's really going to be that simple. Now, separate and apart from that is the estate tax. How do we solve that? Now, first of all, if you're single, you can turn off right now. Okay? Turn off for just a minute, and I'll tell you when to turn back on. If you're married, there is a way that when you die, we're going to split the estate up into two. So we have the decedent's estate. That's the first person to die. Okay? So that's how we always know who the decedent is. It was whoever was the one who died first. And then we have the survivor's estate over here. Now we're going to approximately divide that into two. Now once we divide it, we're going to set some rules over here in the decedent's estate. We're going to say the survivor can receive any of the income if she needs it or he needs it. The survivor can receive any of the principal if the survivor needs it. We're going to set a standard, though, that says the principal can be used for the health, the education, the maintenance, and support of the surviving spouse. Now, simply by doing that, what we do now is this estate right here is going to fall past the wife, if she was the survivor, and then down to the kids, estate tax free. Because let's say there's $2 million in here. I told you the number that you can pass on was $2 million. Let's say there's $2 million in here, and then she dies. That too was able to pass over. What happens if we have more, a larger estate than that? Well, there's a valve right here, okay, like an overflow valve that will say, well, once you're over that $2 million, we'll dump it over here. Now, what is this number right here if we're in the year 2011? It's $1 million, okay, $1 million here and $1 million here. Okay, so that is how we're going to dump that over into the survivor's estate. This next issue deals with, okay, death plans, how are they? Now you can see that a death plan that avoids probate, one that avoids the estate tax, and one that has no questionable distribution, the cost is approximately $1,500. Now I don't want to get into a discussion of, well, why is that so much, or why is that so little? The truth is you can always find somebody who's going to do it cheaper, okay? What we found, however, is that often we see those kinds of people coming back, because frankly it simply is done wrong. In fact, we had a gentleman come in recently who said, I've been to your lecture, and I'm happy to see some of the people here who have been to my other lectures. I've been to your lecture, it was fabulous, and we decided simply to get our documents done somewhere else. I said, great, what are we meeting for? He's like, well, they were done wrong. I said, oh, well, why didn't you go to us in the first place? He said, well, I got a better price. So he ended up paying, of course, for the lower trust, and then, of course, he paid for ours. Is that more or less than what he would have paid if he just started with us? Of course, it's more, and he knew that. And we're going to get into these issues a little bit later about why price can be one issue, but it shouldn't be the only issue. Okay, consider quality, experience, and the type of features that we have in our life plan that we're going to be getting to in a minute. Okay? Now here's a different type of plan up here. This is a life plan. What if we had a plan that had disability protection, that had creditor protection for the spouse and for you while you're alive, asset protection for the children, and then being able to get down to the grandchildren? Now, would you agree with me that this plan here, the life plan, is a little bit different than the features that we have in this plan? This plan is dealing with what happens after we die. The life plan will deal with those issues plus the issues with life, and we're going to be getting into all these details. Okay? Now, before we do, and so that I don't forget, I want to mention something about the grandchildren right here. Almost without question, when we meet with clients, and if they have children, we ask them, if you are to die, they say, we want it to go to the kids. And I say, well, what happens if your children predecease you? What now? And they say, well, we want it to go down to the grandkids. Okay? And that's very common. What happens, though, if their child outlives them? By the way, most children outlive their parents. Okay? So the children outlive the parents, and the child is married. Okay? Now, if the child dies, where's all the money going? To the spouse. Okay? Now, let's say that spouse gets remarried. Where's the money going? Not to the kids. It never got to the kids because it went to the next spouse. The grandkids, that's who we're trying to get this money to, they're out. They got nothing. And I'll show you that with a slide that we're going to get to in a minute. Okay. Let me ask you a question that is not intended to be offensive. How do we know when somebody's dead? Pardon? They stop breathing. Help me out. I'll come to that one in a minute. Yeah. Pardon? Yes, actually it's the doctor. But you're right. And what are they signing? A death certificate. Okay, that's pretty simple. Now, when it comes to not breathing, actually you're not dead. Now, some time ago, no, this is crazy. Some time ago, okay, actually here in Nevada, when the doctors were having an uproar over the malpractice, there was a headline in the RJ that discussed how the doctors were on